Oh, I may speak for more. Well, some said
they are raising the issue, so I had a lot of questions for him. I may not have same number of questions for you, so it may not drag. Thank you.
First of all, it is important to make the point that Japamesa is right when he says that the GBA is entitled to express its opinions on matters of public interest as they deem fit. But what he fails to acknowledge is that the GBA is not the only institution entitled to express an opinion. Mm-hmm. And that when they express their opinion, we are also entitled to express an opinion on their opinion. And the opinion all the people you have referred to have expressed, which I share, is that the claim by the GBA that the president has violated Article 296C of the Constitution in suspending the Chief Justice, and their demand for that suspension to be revoked is mischievous, ridiculous, and disgraceful, to say the least.
They can't have an opinion?
I'm saying they can, but I can also have an opinion on the opinion. And my opinion on the opinion is that their opinion is ridiculous and disgraceful. It is not born out of the law, but it is born out of their own determination to always re-echo the false and contrived narratives of the New Patriotic Party. And what they have done is to expose their true colors. Their true colors as an appendage of the New Patriotic Party. A group of people who always lose their voice when the NPP is in office, but quickly gain their voice when the NDC comes into office. Where was the GBA when President Akufo-Addo, in reliance or in accordance with Article 146(10), suspended, in fact, the Article 146 suspended Justice Derry and 3 other justices of the High Court? The same constitutional provision on the basis of which the president, acting in accordance with the advice of the Council of State, has decided to suspend the Chief Justice is the same constitutional provision that President Akufo-Addo relied on in suspending not one Justice of the Superior Court of Judicature, but 4. Where was the GBA? Where was the GBA when a court of competent jurisdiction was attacked and a pregnant judge molested in the process by hooligans belonging to the New Patriotic Party? Did they even deem it necessary to issue a statement condemning the said attack on a court of competent jurisdiction and a pregnant female judge? Today, President Mahama is in office, so they have suddenly found their voice. This is what you call odious hypocrisy. And the barrage of criticisms, the condemnation that they have received since they issued that hogwash statement is testament to the fact that the people of Ghana have lost respect for the GBA. Look at how they have been made a laughing stock on social media and on all media platforms. Lawyers and non-lawyers ridiculing them, pointing at their hypocrisy, their duplicity. And I feel embarrassed to be a member of the GBA, and I don't think I will ever pay my GBA dues again, because it is embarrassing to be part of this association. But you see, something, let's now go into the meat of the matter. President Mahama did not wake up one day to suspend the Chief Justice. He didn't wake up one day and said that, look, I don't like Gertrude Torkonoo, so you are suspended. This country is a democracy governed by the rule of law. And if our democracy will thrive, then we must uphold the rule of law and commend those who uphold the rule of law. The president was sitting there somewhere, as we usually say in our country, when 3 petitioners brought petitions to his office for the removal of the Chief Justice. These petitioners are not his family members. These petitioners are not his party members. These are ordinary citizens of Ghana who say that they are aggrieved by the alleged unlawful conduct of the Chief Justice. Persons who say that they have been victims of alleged acts of injustice by the Chief Justice. They brought petitions to the President under Article 146 seeking the removal of the Chief Justice. What was President Mahama supposed to do? What was he supposed to do? Throw the petitions away or ignore the petitions? When he has sworn an oath to uphold the Constitution, and a violation of that oath can even lead to his impeachment from office. Was he supposed to ignore the petition because Gertrude Torkonoo is above the law? No, he was not supposed to do that. He was supposed to act in strict accordance with Article 146. And 146 says, when you receive a petition like that as president seeking the removal of a Chief Justice, you shall, mandatory, in consultation with the Council of State, determine whether the petitions disclose a prima facie case. And that is what President Mahama did. He wrote to the Council of State, informing them that he intended to forward the petitions to the Chief Justice. He did so. The Chief Justice responded, filed a supplementary response. The President put all those responses together and forwarded the responses to the Council of State. In the case of Charlotte Osei, former EC chairperson, when he was being removed, under them, the President, who is a lawyer, refused to even give Charlotte Osei copies of the petition which was seeking her removal. The Chief Justice refused her copies of the petition.
Correct. You have corrected yourself. It wasn't the job of the President to give her a copy.
Yes, but after the President directed her to the right forum, the Chief Justice also refused her. She didn't even know who her accusers were. Yet a prima facie case was made against her. In the case of Gertrude Torkonoo, the President wrote to her. She asked for 7 days. President Mahama gave her 10 days. She filed her first response, filed a supplementary response. The Council of State had the benefit of her responses before advising the President that the petitions disclose a prima facie case. 30 out of 31 members of the Council of State. And we are talking about the Council of State, not NDC Functional Executive Committee.
But the NDC people
and the NPP people on the council. That council is made up of some of the most respected people in our society across the political divide. Some apolitical, some retired justices of the Supreme Court. 30 out of 31 said that the petitions disclose a prima facie case. Are we saying that all of them hate Gertrude Torkonoo? They are all NDC people suddenly? And you were wrong last week to have suggested that they determined a prima facie case in all the petitions and counts. No, I can read to you at least 4 counts, okay, in respect of which the President and the Council of State said, no, these allegations don't disclose prima facie case.
Oh,
I can show you 4.
So some of the petitions did not survive.
Yes.
Okay.
Because some of the petitions had multiple counts. So you see, when people like
you mean some of the counts didn't stand?
Yes.
No, that's what we are talking about. We are talking about the fact that all 3 petitions succeeded.
There were petitions. Some of the petitions were grounded on just 1 count, 1 allegation.
Okay.
Some of the petitions too were grounded on multiple allegations.
There was one that had 21 plus, another 4.
And in some of the allegations, the President, 4, I can tell you, 4, the President said there was no prima facie case. So this is not a President who is on any vendetta agenda. The President has shown to be very consistent when you...
Which petition is this didn't get all the grounds?
I have refused to publish these things because I think that the President should have released the prima facie decision on those petitions, and it would have silenced some of these people who are just...
Does the CJ have a copy?
Has she requested for a copy and she was not given?
Is she supposed to request?
She's a judge. When she heard in the news that petitions had been brought for her removal, she requested for copies of the petition. So when she was informed by the President that he has, in consultation with the Council of State, determined a prima facie case against her, why hasn't she written to...
If I go to a court...
And if she writes...
If I go to a court and a judgment is made against me...
You go and apply for the judgment.
No, it will be read to me first. Then if I want, I apply.
So why hasn't she applied? Or has she applied and she was not given?
When I can tell you. When I did the Atlantic case,
let me tell
the CJ gave us a copy of the prima facie determination. Daniel, so we knew what made
this is the
petition
facie of Daniel Ofori. Count 12 and 13. It deals with the dismissal of one Mohamed Musa, a deputy chief registrar, High Court Tamale, and one Richard Bwedi Echampon. The petitioner alleges that the dismissal violates the provisions of Article 151 of the Constitution. Findings: the petitioner has not established a prima facie case regarding these allegations. The documentation provided by the Chief Justice shows that the appointments were terminated on the advice of a committee set up to investigate the complaints against them. Should I give you more? Look, let me give you more. There was an allegation that the Chief Justice had interfered in the execution process of the Kaswa of Angkor District Court in the case of Robert Sawai, operating under business in blah, blah, blah. The finding, a prima facie case has not been made in respect of consisting. The petitioner did not state when judgment was given, when the execution process commenced, or even the nature of the execution that the Chief Justice allegedly halted.
Fair enough.
This was a fair exercise of prima facie determination. They didn't just wake up and said, you brought petition, there is a prima facie case. 30 out of 31 members of the Council of State said there is a prima facie case. And the president said, I agree. And they recommended that, Mr. President, get the Chief Justice to step aside. Because you cannot combine your work as the head, the administrative head of the judiciary, with your rights, as a defendant in this matter. How is he going to concentrate on the most important job of justice administration? How? And is it not even possible that that privileged position can give an opportunity to interfere with the ongoing investigation?
So the demands are unfounded?
Clearly unfounded, and not just unfounded, but illiterate. A Japamesa.
Oh, illiterate to the GBA.
Illiterate.
The GBA of lawyers, 40.
Illiterate.
43 or 47 lawyers.
That is what even makes it worse. The lawyers will refuse to apply binding precedent of the Supreme Court. Settled law. Article 296C of the Constitution has been interpreted by the Supreme Court not once or twice, several times.
Correct.
It has been settled. In the case of Ransford France, the Supreme Court did not make the holding that my brother here spoke about. On page 10, relevant portions. This is what Dr. Dateba said, the respected Dr. Dateba. He says that we therefore, the relevant portion, such an expansive literal interpretation, the interpretation that once regulations have not been published, then the exercise of discretion is invalid. It says such an expansive literal interpretation will lead to a grave mischief. It will lead to a nuclear meltdown, so to speak, of government, as we have known it since 1969. It will be thoroughly impractical for public officials and agencies in general to publish regulations governing their discretions before they could exercise them, on pain of invalidity of those discretionary decisions. Literally, thousands of decisions already taken by public officials and agencies since 1969 will be rendered invalid and will have to be declared so by this court. If we are to go by this warped logic that the president, anytime he has to exercise discretionary power, must publish regulations. This is what is
don't say it's a warped logic.
Now come to 17.
Do you know that even in Ejechum,
Sophia
Kufu and others actually said that there's the need for the rules to be published.
Let's go step by.
I went to the court representing Kukubako and telling the court that they needed the regulations. They had asked for them.
Which year was that?
2005, 2006.
Which year was that case?
I'm talking about Ejechum.
Okay, hold on.
Yeah.
Slow down.
But they threw us out anyway.
Okay. So come, page 17. This is what Ateba concluded. He says, the obligation to make regulations should be limited to discretions that are exercised in quasi-judicial situations. By that, I mean where adjudication is involved. What is adjudication? Adjudication is the determination and pronouncement of formal judgment on a disputed matter. The president exercising a discretion in accordance with advice of the Council of State to suspend or not to suspend somebody. How is that adjudication?
How about the committee? Are they not going to be adjudicating?
They will be adjudicating.
Yes.
But that will involve judicial officers, 2 justices of the Superior Court of Judicature, and that doesn't fall under 296. And even if it falls under 296, in this judgment, the Supreme Court says they can make their own regulations during the hearing of that matter. Now, in the recent case, this is a 2016 case, Elikplim Agbemeva, Alfred Tuyan, and Anasanti Bedietu, when they were challenging the constitutionality of the prerogative of mercy granted by President Mahama for the Muntie 3. On page 28, this is what the Supreme Court said, 2016 case. On a daily basis, public officials exercise some form of discretion in taking decisions. It would be inconceivable to suggest that in exercising such discretionary power, regulations must be published beforehand. Such absurd, these are the words of the Supreme Court, not Sammy Gyamfi. Such absurd and unreasonable expectation, GBA, listen, such absurd and unreasonable expectation could not be attributed to the framers of the Constitution. Having regard to the wide executive powers conferred on the President by the Constitution, it would be literally impossible for him to function if he were to go to Parliament with an instrument to guide him in taking discretionary decisions. Thus, the Constitution has inbuilt mechanisms to guide most presidential actions, whether in consultation with or on the advice of or with the approval of. And once the President acts in accordance with the particular constitutional mandate, as in the instance, he is not required to comply with Article 296C.
Thank you.
No.
That's a perfect place to stop.
No, don't stop there. They go on. The safeguard under Article 72 is the consultation with the Council of State, which seems to have been satisfied per Exhibit AG3. And we do not have any evidence that the Council of State was in any way unlawfully influenced in its opinion to the President, which will undermine the exercise of the discretion. So clearly, the view expressed by the GBA is ridiculous, disgraceful, and illiterate. But before I conclude, Samson, Ejapamesa sits here and say, what wrong has the Chief Justice done? The Chief Justice is not supposed to have done any wrong at this stage. Prima facie determination is not a determination of wrong, is it? You are a lawyer and you are speaking like this. What the President needs to determine is whether or not the Chief Justice has a case to answer, whether the petitions against her are not frivolous. And the Chief Justice herself has admitted to clear wrongdoing in her own responses, which, as I say, radio has serialized. The Chief Justice says that she decided, in fact, her words, you remember the words she used, I opted to use my official travel privileges for a private travel. You go on a private vacation. A private vacation. Some say Ayenene was not aware of this. She would have petitioned for Gertrude Torkonoo's removal. Because when Loretta Lamte used state funds, 182,000 cedis on her private residence, you and your client, you got President Mahama to sack her. This woman carried state funds to sponsor her daughter and her husband on a private vacation and pay them per diem. You are sitting here saying, what wrong has she done? She has admitted.
The suspension,
yes,
is discretionary. And the President could have exercised the discretion otherwise. In Loretta Lamte's case, once the prima facie determination was made by Georgina Wood, we then had to petition President Mahama again and ask him to exercise his power under 146 to suspend her because there were witnesses we wanted to call from Shraj. And while she was there, it would be difficult for us to call them. They would not cooperate. There were documents we needed from Shraj. Suspended. And whilst he did. He did.
And that Loretta Lamte was appointed by Atta Mills, right?
Correct.
When John Mahama was vice president, he gets suspended. So some of you should even be the ones leading the charge.
We asked for it, and we gave a reason why she should be suspended. What's the reason in this case?
That the petitioner must ask for it. The Constitution says that once the Council of State advises that he must be suspended, the President acts in accordance. No, you see, read that provision very well. And I've read Senior Tadio Sori's argument on that matter, and I agree with Tadio Sori. That provision, when construed as a whole, is not discretionary.
Really?
It's not. Because it says the President may, acting in accordance with the advice of the Council of State, suspend the Chief Justice.
Let's read it. Let's read it. 146 clause 10. where a petition has been referred to a committee under this article, the president may, in the case of the Chief Justice, acting in accordance with the advice of the Council of State, by warrant signed by him, suspend the Chief Justice. The president may.
He may, but he says acting in accordance. What does it mean? It means that the president has a discretion to suspend the Chief Justice or not to suspend him. But he cannot suspend the Chief Justice without an advice from the Council of State.
When there is advice, is binding.
He must act in accordance. You see,
okay.
The GBA versus Attorney General case.
I get that.
Look at the operative words.
I get that.
On advice of.
I get that.
This is not on advice of.
I get
this is not in consultation with. This is in accordance, but assuming without admitting that it is even discretionary.
Okay.
The president says, "I agree."
Your point is made.
Look, and before I end, just one second. This woman has been accused by a lawyer and a senior police officer for tampering with court documents, falsifying search reports.
Okay, can we pause here?
No. She's been accused of doing that.
Let's avoid.
I'm choosing my words.
Let's avoid the situation of prejudice.
This man was sitting here asking you what wrong. I'm telling you the wrong.
The GBA's earlier statement cautioned all of us. And you're a lawyer. He's also a lawyer.
They have turned around to prejudice the very matter they
on the suspension. On the suspension.
Yes, they are prejudiced.
Thank you.
But my point is that let me just give me a very comfortable land. My point is that we are talking about serious allegations.
Okay.
In some cases involving a lawyer who, in his opinion, has been wrongfully imprisoned, incarcerated. And the Chief Justice ordering an officer of the court to falsify court evidence.
Please, okay, thank you, Sammy.
And you want this,
Sammy, thank you. Hold it there. Thank you very much. Now, thank you.